This House is now in session.
Government notices.
Mr. Speaker, I beg to give notice of the resolution that the sum of $9,908,186 be granted from the Consolidation Fund and be placed at the disposal of the government to supplement the estimates 2018 to 2019 as shown in the supplementary estimates number 4 of 2018-2019, which form the schedule to this resolution.
We commit who?
Seconder.
Government business.
You don't need a second.
Government business is now the order there. Prior to the suspension for lunch, we were debating the revision law reform bill. To that, we now return. The honourable member for St. Peter.
Thank you very much, Mr. Speaker. I stand this afternoon to give my support to this law revision, law reform bill that is before this honourable chamber. And I'm not going to be long, Mr. Speaker, because I believe it is evident, maybe almost self-evident, that this is a bill whose time has really come. There are two, and I'm speaking obviously from the perspective of a non-attorney, but there are two aspects to the bill that is before the House that I would just want to repeat, because it is in that context that I will make my few remarks. As it relates to law revision, my reading of the bill and listening to the Honourable Attorney General as he piloted the bill gives me the understanding that law revision, the rules involved in that aspect of the bill's work, or what will become the act, speaks to creating the online database, electronic database, updating laws, making sure that the most current versions are available, making very minor corrections, punctuation, and any other minor errors that may be in the bill at the time when it came through the chambers of the House. And the other one, law reform, speaking to developing, modernizing, and simplifying the law. Now, I think these two aspects of the bill are very important. And much has been said about this morning, but the entire aspect of law reform is one that really warrants our attention. And I want to commend the Honourable Attorney General for bringing this bill to the House, because we operate in a very international arena. We are a small island developing state, but we exist in a real world, a globalized world, and that is not to say the world has not always been a globe, but globalized in the sense that there is a connection now that was not in existence maybe a few decades ago. Everything now is happening in real time. And as situations develop, as societies evolve, that information crosses the globe, moves around the globe almost instantaneously. And so the world is rapidly changing. And I agree with the proposals in this bill, because it is necessary not to wait 20 or 30 years to update legislation. But as best practices become evident, as we learn what is happening in other places and not copying them, but as we recognize that we can make adjustments so that our legal system can better function, then I think it's appropriate that there be a system, a body set up to allow us to execute these changes, bring these new laws to the fore in the shortest possible time. Because we live in a world where people are no longer prepared to wait, business activity is no longer prepared to wait, even social sectors, educational development. There are many things where speed of response becomes important. And as I said before, we exist in an environment, a global environment, and we need to respond to that environment. Now, Mr. Speaker, my remit, not as a member of the legislature, but my remit as a member of the executive or the cabinet of this country allows me to have a certain oversight over the labor legislation in Barbados. And there are a number of laws on our books that relate to workers and work and the work environment. Maternity leave, national insurance, social security, holidays with pay, severance pay. The Labor Department itself is governed by an act. Employment rights governed by an act. Protection of wages, accident and occupational disease notification, radiation protection, occupational safety and health, or the act is called Safety and Health at Work, sexual harassment. And these are most of them, but not all. But I say to you, Mr. Speaker, that as the world of work develops, as the world of work changes, there needs to be a mechanism that allows for the updating of the legislation that impacts the workers of this country. I have this conversation with persons in my ministry from time to time. I do not like the term labor, even though I'm the Minister of Labor. I do not like the term human resources. When I studied economics at university, we were told that the three factors of production was land, labor, and capital. And as a person who grew up close to people in the country, in Rosehill and St. Peter, I have never been able to equate people, human beings, to land and capital. I see people as distinctly different. Human beings made in the image of God. And so as it relates to the laws and the legislation that governs how human beings work or how they are treated in their places of work, I am of the view, Mr. Speaker, that there is a need to ensure that the legislation that governs human beings can respond to issues that arise from time to time. Radiation, occupational safety and health, those are matters that maybe 20, 30 years ago were not on the front burner, so to speak. Nobody really thought about radiation outside of nuclear power plants, and we don't have them here. But we have cell phones, we have all kinds of gadgets, whether they be computers or tablets or laptop versions of computers. Possibilities for radiation now exist all around us. 30 years ago, not a lot of people really place a lot of importance to maybe the type of chair that you sat in at work or the height of the desk. But Mr. Speaker, these are now issues that are not just on the table, but we are working with implements of work that are in constant development. And we have to keep up with what is happening as these tools of work develop. And so it is important, for example, when we talk about radiation or occupational safety and health, that our legislation is able to respond quickly. That means, Mr. Speaker, that somebody has to be doing it. And when legislation falls within ministries, those of us who are ministers and those who lead in ministries find themselves and find ourselves on a day-to-day basis taken up with what we call the work of the ministry. And so not a lot of attention is paid to ensuring that the legislation is keeping pace with the development of society. Law revision, as it relates to the online databases that are to be established, are critical in situations, and I speak somewhat from a business background, small to medium-sized business. And I want to say to you, Mr. Speaker, and to this chamber, that almost every organization, not just businesses, but almost every organization has employees, people who work in the organizations. Most of the industrial relations issues are as a result of, but I should probably say most, many of the industrial relations issues, the challenges, the go-slows, the strikes, come as a result of a lack of knowledge on the part of those who are tasked with supervision and management. I didn't say most because there are some, maybe a few, hopefully no more than a few, genuinely wicked employers. But I don't think that there are many. And so that is the reason why I didn't want to say most, because I haven't done any empirical research. But there is a lack of information on the part of many who are tasked with leading. And I want to submit, Mr. Speaker, that some of the reason for that may be the unavailability or the lack of ability to quickly reference particular pieces of legislation and particular sections of those pieces of legislation. And I want to submit to this House that having the laws in a place where they can be easily retrieved by anybody on the go with their electronic devices is a step in the right direction. Because if an issue arises on a Saturday night in a hotel somewhere in Barbados, and you cannot get a hold of the HR manager, or you're in a small business and you don't have an HR manager, you can't call the organization that may assist you in helping you to resolve these matters. Having the legislation online in a place where you are sure that the version is credible, and that is what this bill speaks to, ensuring that the version that appears in the place where it will be reposited online is a credible version, an authentic version. Having that version of the legislation available to supervisors and managers places them in a better position to respond to challenges that may arise in the workplace. And I say to us, Mr. Speaker, that issue of access to the laws of Barbados is a very, very positive development. The challenge, I've worked in organizations where we've had the paper version. But we have many situations in Barbados where there are businesses with multiple locations, where the HR department is located at one of the locations. And there is always the challenge of trying to reference a piece of legislation, but not being able to put your hands on that piece of legislation. So it exists in the company, but it's not readily available. And I'm saying, Mr. Speaker, that as we develop as a country, as we develop as an economy, we live in an age where everybody expects to have access to information. Accurate information, relevant information, but access in a timely manner. And there's absolutely no reason why the laws that are made in this honourable chamber and in the other place that are made to regulate business and other kinds of activity in the country should not also be readily available to the people of the country, those who are subject to the laws, and to managers and supervisors who have to enforce or interpret those laws. And so I want to particularly commend having the laws of Barbados in a place online where they can be easily accessed. I think that is a positive development, and it is one that the Attorney General must be commended for in terms of bringing this bill to this honourable chamber. As it relates to not now revision, as is termed by the bill, but reform. This matter of reform is being spoken about. I heard the Honourable Leader of the Opposition speak to it this morning. In terms of international trends, I, like my friend and neighbour, the Honourable Member for St. Michael's South, am not fearful, and by way of using an interpretation, I'm not as fearful as I seem to think the Leader of the Opposition is. And I put it that way so that I can avoid an interruption, because it is simply my interpretation. There are certain international trends in what is called labour matters that are extremely positive. There is and has been on the agenda of the International Labour Organization for a few years now the concept of decent work. Decent work because work is performed by human beings. There is the concept of, and I think the Honourable Leader of the Opposition spoke to this morning, rather than being fearful of multinationals, there is a move, and it was part of a conference, a series of meetings last week that dealt with this, but there is a move to ensure that there are regulations, and in some cases legislation, that will ensure that multinational corporations, supranational corporations, respect people, respect the environment, respect the countries within which they operate. And those kinds of international developments are good things, because as the ILO pushes these kinds of initiatives, then we need, as they are pushed internationally, as we recognize that there are not just good practice, but best practices, we ought to be in a position to have our legislation reflect these developments, so that we are not put in a position where, because we are a small country, we get to a place where we are at the mercy of these multinational corporations. So that is an international development that ought, in very short order, to be reflected in the legislation coming through this Honourable House and part of the legislation that governs our country. There is also developments at the international level in relation to environment and environmental standards, good developments that ought, in short order, to be reflected in our legislation. We've spoken, and internationally, we've spoken and discussed and engaged with organizations on the matter of removing discrimination from the workplace, whether it is discrimination based on gender or based on disability. Those are positive developments that ought to be reflected in short order in our legislation. There is a move to ensure that women and mothers are treated equally in the workplace, that women are paid on an equal basis based on the value of the output. Equal output, equal pay. Those are developments, creating situations where mothers can perform their roles as mothers, not to the disadvantage of themselves while they are part of their workplace. And Mr. Speaker, I would want to submit to you that those are developments that speak to treating workers as human beings, that this act, when properly put into place in the area of law reform, we will have persons whose responsibility it is to make sure that these very positive developments make their way to our legislation, therefore improving the lives of the workers of this country and also improving the existence of people in this country. The right to collective bargaining, another international development, but one that speaks to and understands that the individual worker does not stand on equal footing with an employer, especially when the employer moves from micro and small into the realm of medium and large enterprise. And so the concept of collective bargaining, solidarity, as it is called in the trade union movement, is one that needs to be reflected in our legislation. And this party, the Barbados Labour Party, the party that was formed and founded out of the struggle of workers to overcome the hardship that they were forced to face by the then planter and merchant class, this Barbados Labour Party, in its manifesto of 2018, has committed to a recognition of trade unions legislation, because this Barbados Labour Party recognizes that we need to enshrine in legislation the rights of people to bargain collectively. But I mention that because these are international developments that we must embrace. These are international developments that speak to the lifting of the standards in the workplace, that speak to really recognizing the value of human beings and the value of the output of human beings, of workers in the workplace. I applaud legislation that will allow for the international environment to be scanned on a continuous basis, that will allow us to see best practice, that will stop us from having, in some cases, to reinvent the wheel, and will allow us to be a little bit more proactive in ensuring that our legislation is at world-class standard. Legislation becomes important because, Mr. Speaker, as a highly respected criminal attorney yourself, it is understood that even though there are conventions even though there are generally accepted ways of doing things, there are still people who are prone to deviate from what is right. And the only way to manage that, the only way to properly govern a society is to enact legislation. Not that will necessarily change people's attitude, but that will govern their behavior. And I want to say, even as I speak as Minister of Labour, and I'm going to say this very deliberately, as Minister of Labour, and I spoke about collective bargaining, all the rights and responsibilities, but the rights in this case that workers, human beings must have. I would want to say that ignoring the international developments in the international community, putting ourselves in a position where we are constantly reacting and reacting sometimes decades later, will not cost us less, it will cost us more. And I use cost us less very deliberately, and that can be considered by all those who are listening to be a shot across the bow. I, Mr. Speaker, want to support this law revision and law reform bill that is before this honourable chamber. I commend it to the chamber. I see it as progressive because it allows us, in my view, to catch up with the international community, to understand that we are living in a world that is not just changing, but changing rapidly. It allows us to be in a position where we can change as rapidly as our community, our society, and our world is changing. Mr. Speaker, I'm obliged to you.
The honourable member for Christchurch South.
Thank you, Mr. Speaker. When I first came to this Parliament, nothing excited me as much as the government's early proposal to make university education free and accessible to all the young citizens of Barbados. Today I will say to you, Mr. Speaker, that this proposed legislation excites me almost as much as what this government did a few weeks ago. As I always say, when one speaks here, one is speaking equally to the public. And in speaking to the public, one must bring certain matters to the attention of the public that may not be known among the members of the public. And I begin with the very basic information that this Parliament has the sole purpose under the law of passing laws. That is our purpose, to pass laws. Indeed, Section 48 of the Constitution says to us, if you would permit me to read it, that the purpose of this Parliament is to pass law. It gives Parliament the power to pass law for the peace, order, and good government of Barbados. That is our sole purpose. And law reform is an important part of that task. Not only are we here to pass law in a modern context, but it is a part of our mandate to look at the laws that existed prior to the life of this Parliament, look at the laws that existed even prior to the life of an independent Parliament. And when I say independent Parliament, I mean I'm referring to the Parliament that found life after November the 30th, 1966. Perhaps a lot of persons in this country are not aware that a lot of the laws that exist presently in Barbados are pre-independence laws, and I treated to this matter a few weeks ago on the other debate. But a lot of those laws that still exist in this country are pre-independent laws. A lot of the laws that exist even after independence are in dire need of updating, in dire need of reform. And therefore, a part of the mandate to pass law includes the requirement that a modern parliament should attend to the business of law reform. I mentioned the colonial parliament, and you would be aware, Your Honor, that laws really spring from the social relations that exist at a given time. Laws tend to be influenced by the social relations, and social relations themselves tend to be influenced by property ownership. In a colonial Barbados, for example, you would have had a few people owning most of the property, and as a result of that, the social relations that would have existed between the citizens of the country would have given rise to laws which we would now consider unjust. And a parliament does not function properly unless it seeks to address questions of injustice, unless it seeks to address questions of social injustice. And not only are we here for the purpose of passing laws, but we're here to redress historical injustices that would have existed in this society prior to independence. We should not feel squeamish about that. We are adults, we live in the real world, and by now we all understand that this parliament has a mandate, as I said, not only to pass law, but to reform law that was inherently unjust. In terms of reform, there are two agencies that tend to address reform in the law. If a law is considered bad law or if a law is considered unjust. Two agencies have historically tended to address law in need of reform. That first agency, of course, is the court. As you know, Your Honor, the court likes to say that they do not make law, that they just declare the law. We who are lawyers know that that is probably mythological. I mean, the courts, there are many courts over the years that have made law, speaking truthfully. But the court has been limited in its reform initiative. The court has from time to time updated the law. The court has from time to time given reform to law. But the court has limited itself by that self-description of not being an agency that makes laws, that it is an agency only that declares the law. But from time to time, there has been a need in the courts to reform law. And that has been met with much difficulty, because the court itself has, the evolution of law in the courts has been stifled by this doctrine of precedent. In other words, when a court is giving a judgment, when a court is declaring what is the law, unhappily the courts in the Caribbean have not functioned always with intellectual and academic independence. That is a fact. We have gone to the courts in this country and in this region, and before we have presented on what is the law, too many of us as lawyers have tried to determine what has been the law in England, what has been the law in Canada, what has been the law in New Zealand and Australia and even South Africa, before we can ourselves say what is our law. In other words, we have been tied too often and quite unhappily to the laws of other countries. And even judges have found themselves, I think, on occasion excessively influenced by the declarations of law in England. I speak, Mr. Speaker, as a modern lawyer. I hope I am. I speak as a modern lawyer, and I speak as a lawyer in a modern society. And I think it is an unhappy state of affairs that in 2018, we are still too dependent on the judgments that emanate from England and New Zealand and Australia, and in a few cases in Canada. I think the time has come for legislative and legal sovereignty in a real sense, in that the courts in our part of the world give themselves the right and the opportunity to say what our laws are, based not on precedent, based not on what happens in England, based not on what happens in Australia, but based on our prevailing reality. I want to bring a very live case of that to this chamber, Mr. Speaker. Some time ago in the Bahamas, and some time ago in Trinidad, there were two significant cases that touch on that issue in a very real way. And my colleagues here should take some note because it affects us as well. It had to do with this thing we call the chattel house. The chattel house. And we have chattel houses all over Barbados. And the law in England was that if a man placed a chattel house on land belonging to another person, if that house was so affixed, so permanently affixed to the land, when he wanted to move that house, to relocate that chattel house, if the court found as a matter of fact, as a matter of engineering fact, that chattel house was too firmly or permanently affixed to the land, they called it, Mr. Speaker, and you know this, they called it a fixture. In other words, it became a part of the land. Now this phenomenon...
I remember, quid plantatur solo seeded. That is the Latin phrase. That is the Latin phrase.
You can't beat a Combomerian for Latin. Up and on.
That is the Latin phrase. What is affixed to the land is the land.
Is the land. You can't beat a Combomerian for Latin. And therefore that became the law in England. And here's the poor tenant. He's renting the land, but he affixes the chattel firmly to the land. And as you remind us, Mr. Speaker, the courts in England rule that it becomes a part of the land. And therefore, it disenfranchised the tenant. Who is the owner of that chattel? Who spent his money and put it there? Now, this same thing existed in Barbados. We, those of us who know the history of Barbados, and we've just gone through an election. So the realities in this country are not foreign to us. And we know that in the 1960s and before, most chattel houses were planted on the land, almost literally planted on the land, without any effort to permanently affix them. And so on Sunday mornings, you would see a large group of men come and they lift the house onto the back of a truck and they would take it away. And that demonstrated that the house itself was not firmly affixed to the land as to make it a fixture. But the 70s came along and the 80s came along. And you know, sir, what was the phenomenon? What happened? That a lot of persons with greater prosperity, although they were renting the land, started to firmly affix those chattels to the land. In other words, they built toilet facilities at the back out of wall. The foundation that used to be soft stone, you and I know these things, sir. The foundation that used to be soft stone, that became cement blocks. And they actually planted the wooden portion of the house into those cement blocks. And according to the law of England, that chattel house with that wall toilet facility at the back and sometimes a kitchen, that became a fixture. The law deemed that to be a part of the land and deprived the tenant of his property, because if it becomes a part of the landowner becomes the owner of that chattel. And perhaps the law, not perhaps, the law is saying to him, if you have put a chattel there and affixed it almost permanently, it belongs to your landlord, and quite possibly you cannot move it. Now, that is the law. But as you know, Mr. Speaker, the law often promotes injustice. We all know that it was unjust. That it was unjust, I beg your pardon. This issue arose in Trinidad in a case called Mitchell against Cowie. And the court had to address this question. Do you apply the strict law of England, which was unjust in a Caribbean context, or do you change the law of England to promote justice? The court there arrived at a compromise. The court said, well, we are going to describe it as a tenant's fixture. We rule that it is a fixture. And remember, Mr. Speaker, if we call it a fixture, it belongs to the owner of the land. But the court reached a compromise there and said, okay, while we choose to apply the law of England, we will give a decision in which we will describe it as a tenant's fixture. In other words, we are saying it is a fixture according to the law of England, yet we will allow the tenant to take it. We call it a tenant's fixture. That, Mr. Speaker, still was not satisfactory. The justice required that if the gentleman who owned the house and put it there and affixed it permanently, for his own comfort and for the comfort of his family, justice would require that if he has to move, if the gentleman is not selling him the land, if he cannot afford the land, then he should be allowed to move. What the law of England said, at that time, he may not be allowed to move. And that was the case Mitchell against Cowie. Happily for us, there was another case that arose in the Bahamas, O'Brien Loans against Mizik. And in the case O'Brien Loans against Mizik, the court went farther than the Trinidad decision. Indeed, I will pause and remind Your Honor that the Trinidad decision involved the great Chief Justice Sir Hugh Wooden.
That is correct.
So that the public must understand that this was no legal trifle. These were judges of great eminence and great reputation. In the Bahamian case, another judge of equal eminence, Sir Telford Georges was the name, who had been a Chief Justice of Tanzania. And I say this not merely to celebrate the names of these persons, but to indicate that matters of this importance were dealt with by men of great eminence. And men of great eminence sometimes differ. And men of great eminence sometimes fall into error. I want to commend Chief Justice Georges, who did the case in the Bahamas. And they commented on the law as it existed in England. But they chose not to be influenced by the law of England. What they did, they looked at the social reality. And they recognized that in the Caribbean, that the reality was that men and women did plant their house with permanence on the lands of landlords. And sometimes those landlords included the government, because we had a lot of government estates all across St. Michael. I know my colleague from St. George South, he would be more familiar in his constituency with the plantation tenantry, in which the owner of the land would have been the plantation. Well, I say to my good colleague that in St. Michael and Christchurch, the phenomenon would have been that of the government being the owner, and therefore you heard of government estates. And I'm not talking about housing areas, I'm talking about government house estates. And the church, yes, the glebe lands. So that landlords were not only individuals, landlords were very powerful entities, not including plantations and including the government and including the church. As my learned friend, the Honourable member for Christchurch West reminds us that the church was a very powerful landowner as well. But the point is, in the Bahamian case, the court turned to the social reality. The court did not subscribe to the law of England slavishly. The court thought that the proper way to determine the case and to determine the issue was to look to the social reality, what obtains, what is just. And so the court rejected the precedent that had been set in England. And Mr. Speaker, I submit that, I present that merely to make the point that when we come to reforming the law, we must always look not at what was the previous law, but we must look at what is the social reality. We must emulate the court in that Bahamian case that made a decision, that made a determination based on the social reality that presented itself in the country at the time. Credit must be given for that methodology to the American Roscoe Pound, an American jurist who lived in America in the first half of the 20th century. And he propounded, no pun intended, the theory of social engineering, in which he said that when one was making law, even in the courts, that when one was declaring the law or making the law, one ought to subscribe to this principle of social reality, that too many lawyers tend to approach the law as a monument, something you bow before and praise as a thing in itself for its own virtue. I want to say to you, Mr. Speaker, that the law ought not to be considered a monument. The law is an instrument, and the law is an instrument for social change. Sometimes the law is there to promote social change. Sometimes the law is there to reflect social change. But ultimately, what the law ought to do always is to embrace justice. Whether we are trying to catch up with social reality, whether we are trying to promote that change, as I've said, what the law ultimately always should try to do is to embrace justice, to create a situation of social justice, and to create relationships among the members of the society that are just. And so to come back to the Trinidad and Bahamian cases, I want this Parliament to emulate what the court in the Bahamas did in establishing this law commission, to embrace that principle in which the law and law reform marries itself to the social reality, in which law reform always must marry itself to the need for social justice. And I am particularly excited by this, the establishment of this commission pursuant to the passage of this act. Nothing really that we do from here on will be quite as important as this. We have several ministries in this government, and I am absolutely certain that every minister, when he looks at the work involved in his ministry, will find that there is a crying need for reform. I happen to have seated next to me the Minister of Commerce, and he has told me that there is need within his ministry for reform. The Minister of Housing was here this morning, and I think his junior minister is here as well. There always is a need for reform in the area of housing, in the area of regulating relations between landlords and tenants, in allowing tenants to make that easy, smooth, and affordable transition to ownership, as was done in 1984 with the Tenant Freeze Freehold Purchase Act, which we all have described as revolutionary. That is what law reform is about. Law reform is about implementing progressive change. So that I want to concede that it is in a modern society not possible for an Attorney General to undertake law reform by himself, that he needs to be in partnership with all of his cabinet colleagues. He needs to be in partnership with all of his parliamentary colleagues, including you, Mr. Speaker, to discover the areas of social reform. And when you discover areas of social reform, you marry that social reform to legal reform, because ultimately, as I've said before, our purpose here is to pass law. There's no other larger purpose than our purpose of passing law. And as I've said before, the mandate to pass law includes the mandate to reform the law, to reform all law that is unjust, to reform all law that is irrelevant, to reform all law that is not suited to a modern Barbados. So having said that, I want to tell the Attorney General that what he has done, I did not even know, I admit this publicly, I did not even know that this was on his agenda. And it has taken me by most pleasant surprise that the Attorney General, so early in his term, has done something that past parliaments never did. And I want to personally and professionally congratulate the Attorney General for bringing this legislation in the month of October, the best month in the year, incidentally. And he makes the distinction between law revision and law reform. I am less interested in law revision. Law revision is a technical matter of somebody coming and changing, adding punctuation marks and that kind of thing, committing it to databases and so on. What we are more appreciative of is the more fundamental initiative in reforming the laws of this country to bring them into concordance, if you wish, with the social reality that presents in this country. Nothing has excited me as much as this, and I want to congratulate him, and I want to congratulate all those persons who may be connected with this initiative. If it ushers in, if anything will usher in a new era of social justice in this country, it is this legislation. He himself very modestly described it this morning. I heard him on my way down. He said that it is not sexy legislation, that it is not the kind of thing we can go back and boast about to our constituents, but I beg to differ. I certainly will be saying to Barbadians now and in the future that the establishment of a law reform commission is one of the most significant legislative occurrences in this country for a long time. This Parliament recently consulted the public on the integrity legislation. Who is to say from its source, a law reform commission will receive its information? He has indicated to us that it will receive its information from the ministries of government, and that is good. Will it also receive its information from the wider public? And this government has shown a willingness to deepen democracy, to go into active consultation with the public when it comes to the passage of law through this Parliament. And this is a brilliant initiative in that the establishment of a commission now opens up the doors of Parliament, now opens up the door for law reform to the public. And I would expect that a law reform commission will be populated not only by lawyers, but by sociologists, by political scientists, by engineers, that every person representing every progressive interest group in this country, the church, that all these persons ought to have access to law reform in Barbados. And what a beautiful way to do it. What beautiful democracy it is to set up a law commission so that we are saying to the people of Barbados that we are not omniscient. The Attorney General is himself saying that he is not possessed of all the knowledge in relation to law, but that the people and the people's participation will be the way to move law reform forward in this 21st century. I am extremely pleased to support this legislation, Your Honor, and with those few words, I'm obliged to you.
Honourable Member for St. James South.
I rise, Mr. Speaker, to lend my support to the Law Reform and Law Review Bill. I want to start off, first of all, by expressing my thanks to my colleagues for supporting the women of Barbados by showing solidarity, wearing pink. All of you have done extremely well in expressing yourself and your support for us by identifying with us in that color, including you, Mr. Speaker. We appreciate it very much. I also want to express my gratitude for this particular bill and for the presentations that have been made by my colleagues about the importance of this bill. I too, like the member for Christchurch South, feel that it is important, it is to be celebrated because it is going to make a tremendous difference to life here in Barbados. And unfortunately, that is a fact that tends to escape the ordinary citizen. I myself, as an ordinary citizen, did not appreciate what was the importance, for example, of having a parliament and passing laws. I thought maybe, well, no, occasionally you would need some laws to lock up some criminals and do one or two things. And that was the kind of mindset that I took with me most of my young adult life. It was only in coming into the political arena, and not even when I first came, but when I became a senator, and now even more so is reinforced now that I am a minister, the absolute importance of laws and the passing of laws and laws being fit for purpose to enable a society to get forward. I never appreciated how every initiative that you want to take as a minister required some piece of legislation to give life to that initiative. Whether you wanted to make serious changes in some part of the economy or the society that needed to be upgraded to allow us to advance as a modern society. So when we wanted to get into the blue economy, when we wanted to start looking differently at our maritime affairs, a whole slew of legislation is going to be needed to support our efforts in that area. When we wanted to bring culture forward and make sports important in the entire functioning of the society, where the people who engage in those activities would be able to pursue it in a way that they could make a meaningful life out of it, it required some form of legislation to make it happen. But before I had the experience of recognizing how important legislation was for the advancement of a society, I used to hear other leaders saying, especially when the last administration was in, I remember hearing the comment, but the country cannot go forward. Parliament is not meeting. And for a long time, at first I couldn't figure out, well, the frequency of Parliament meeting, what has that got to do with the country being able to go forward? It is only now that I recognize the absolute importance of the work of the Attorney General and his chambers, the work of the Parliamentary Council. All of those are so critical to bringing the legislation to support everything that we sit down and discuss. And therefore, in a modern Barbados, if it is to go forward, one of the things we have to do is to empower the Attorney General's chambers to be able to function, whether or not they have a deep need for resources, whether they have a need for personnel, whether they have a need for modern equipment. That a government that is seeking to make Barbados fit for purpose must pay careful attention to ensuring that the Office of the Attorney General gets what it needs in order to be able to carry out the business of the country so that we can prosper. And I want to publicly now express my thanks to our Attorney General and to his team, that work tirelessly to ensure that legislation is constantly flowing out to support everything we're doing, whether it's in agriculture, whether it's in sport, whether it's in education, whether it's in commerce, whether it's in international business. I sincerely want to thank them for it, because it is how we are going to make ourselves fit and ready for a modern world. The other thing that caught my attention in the Attorney General's presentation was the fact that the laws will actually go online. I cannot tell you how relieved I will be to have access to the legislation in e-form. Because, Mr. Speaker, the laws are many, and trying to follow what is happening is very difficult when you're trying to track it by paper. And unlike him, the Attorney General carries himself in a very youthful format, so I anticipated that he would have been happy dealing with the technology, but apparently he still prefers the paper versions to operate with. Well, I can tell you from my own experience in studying, when I was doing my master's, I was never so grateful for having all that material online that I could study without having to buy books at $350 a pop, and to be able to study any part of the world, because I had to travel while I was studying, to be able to access the information that I needed. So I'm very pleased to be able to support this piece of legislation. I think it is long in coming. I think it will help to revolutionize Barbados and help us in a meaningful way. Now, from the perspective of the Ministry of Foreign Affairs, it is absolutely vital for our work in the Ministry of Foreign Affairs. In Foreign Affairs, our task as a ministry is to be able to take the domestic policy of Barbados, understand what needs to be done so that we can achieve those objectives, and then engage the external environment, engage the international environment to seek to be able to find, whether it's resources, whether it is to find cooperation, whether it is to get agreement from others that will allow us to advance our domestic agenda onto the global stage. And therefore, it is very important that we maintain good relationships. It's very important that we sign off on agreements and treaties that help to give life to the Barbadian domestic policy. Hence, quite often, Barbados is asked to engage in agreeing to a number of treaties. We agree to a certain course of action, whether it is in relation to human rights, whether it's in relation to security, whether it is in relation to the proliferation of arms. There are a number of things internationally that Barbados has to agree to in order to be part of the international community. Now, when we go out and make those agreements, it is absolutely necessary that we follow on by passing the necessary legislation in a timely way that meets the promise which we have made on the international stage. And therefore, an alert, agile, flexible, efficient Attorney General's office is critical to helping us to honor the things which we have said, because all of this links back then to our reputation as a nation, our image and our brand abroad, and that in turn determines how other people deal and treat with us and whether they deal with us seriously. If we take seriously the promises which we make and we follow through in a timely way, you are dealt with differently than if you are delinquent. So the Attorney General's office is critical to us, and so the law revision, the law review is going to be important. One of the items that is heavy on the Attorney General's agenda has to do with what has happened in terms of international business. Barbados has signed off on a number of treaties and so on with countries. And in the OECD and in the EU, there are a number of things that they require us to do to be compliant with the International Financial Services Order. And a review was done recently of the level of compliance Barbados has. And what we've discovered is that over the past 10 years, Barbados has lapsed in a number of areas where we needed to be compliant. And so they compiled a whole set of areas in which we need to make ourselves more compliant, that we can be competitive. If we don't do these things, we will find it very difficult to compete in the international financial services sector, which will affect the economy of Barbados. And so the Attorney General has taken the lead to pull together the various ministries that we need to sit down and go through that legislation and make sure. So there's a lot of work coming up ahead that the Attorney General's office will find itself having to deal with, the Chief Parliamentary Council, etc. They have to work on these things and help us to be compliant, as well as other ministries doing things to get us there. So one of the things that I want to point out in relation to the whole issue of the law reform and the law revision, I've spoken about how it affects us in foreign affairs and our responsibility to ensure that we are compliant with what we have agreed to so that we can operate internationally. But one of the things that concerns me as a Barbadian is the fact that obedience to the law is breaking down. That we have a generation that is no longer willing to comply simply because there is a law. And so what we're having is a breakdown in the society, because as yet we have not found a way to help this generation to understand the importance of that law. Even something as simple, Mr. Speaker, as the traffic lights just around the corner. When you come down, you want to turn onto Marhill Street. Barbadians no longer obey the law that says that they cannot cross unless the light says to cross. They walk at will. And then on Palmetto Street, they walk all across the road. They don't look back. If they look back and they see you, the attitude is, you better wait till I cross, you better not hit me. And what that says to me is that there is something going on in our minds and our hearts where we are now deciding as a nation, picking and choosing what we will obey and what we will not obey. And this is a very grave danger to any society, because law and order can actually break down. This is one of the reasons why law review is important, because you have to examine whether a law is still relevant. You have to examine whether or not it can still deliver, if it is still doing the job. So this is important so that we do not get a total breakdown in our country. But we have to go the next step. How are we going to get that law written on the minds and the hearts of citizens so that they keep it from inside? Now, sir, the Bible tells us clearly, you have to take the law, bind it around your neck, write it on your heart, put it on your sleeve, put it on your head. When I first used to read that, I used to say, but God liked to make sport, because the Israelites at that time felt that they would just write it, put it in a box and tie it onto these different places. They missed the entire point. The question was, how are we going to get our people to internalize these laws and live these laws from inside so that the society could be orderly? And I've discovered something, Mr. Speaker, that while we will review our laws, while we will change them and make them up to date, we now have to find a way to inculcate those laws into the minds and hearts of every Barbadian so that we can live well. And to do that, they first have to understand what is the purpose and the reason for the law. Society cannot function without laws to govern our relationships, our interactions. The law has a very strong purpose, a very strong role to play in the strength of any society. The law is there to manage our cooperative network. That's what we live in, a cooperative network. Individuals seeking to pursue their interests, but doing it together in varying groups and changing those groups and changing those activities, but it must be done in an orderly way so that everybody can participate. And the law allows us to do that. What it does, it gives us the opportunity to to participate. So it's there to create fairness. It helps to manage integrity in the system and to balance the power relations in the system. It helps to create certainty so that you know that if the law says you buy property and you pay property tax and you mark off your property, that you're allowed to do X and Y on your property and other people are not allowed to do it on your property. That creates certainty for people. And this is why law is important. It creates certainty. It also helps to curtail, circumvent, and control those who wish to violate those agreements that we have. When we are able to get everyone in our society buying into the laws and living out those laws, then Barbados will be fit for purpose, and Barbados will be ready to be competitive. I want to thank those who are going to sit on the Law Review Commission. One of the things that I've come to appreciate very much, Mr. Speaker, having been in office for 4 months, is the wide number of people who work on behalf of the 280,000 people who are citizens of this country. That they're persons who spend their life, who make sacrifice and service a part of what they do, serving the rest of us with their skills, with their energy and their talent. And many of them are unsung heroes. But I want this evening to recognize each and every one of them, because I have a deep appreciation, a deeper appreciation now of the impact and the effect those persons have had on our lives in helping to make Barbados better and to make my life possible. And those commissioners who will come on to that Law Review Commission, the Law Reform Group, when they sit and start to work with our laws and streamline them, when they start to work in putting together the changes that will help to make our law fit for purpose to take Barbados into the 21st century and beyond, that they will be doing a signal service for this country that must be recognized, because without the effort that they are going to make to help us create a modern Barbados, Barbados would lag behind the other nations of the world, lose its grip on becoming a modern society, and therefore consign its citizens to a life that is retarded and a life that is not sustainable. And that is why I want to endorse fully this piece of legislation. I want to thank the Attorney General for his presentation and for bringing this piece of legislation. I hope that we have time in the future, as we start to do the law review and make the changes, that we engage the citizens in ways that help them to understand the law, so they understand their rights, they understand their responsibilities, and that we all begin to regulate our behavior according to the law, because this is what will bring peace and bring prosperity to this nation. May God bless every one of you who will work together with us in this endeavor to give us a better nation. I'm obliged to you, Mr. Speaker.
Honourable Member for St. Philip South.
Thank you, Mr. Speaker. I rise in support of the law for the revision and the reform, or the Law Revision and Law Reform Bill 2018, as it is so called. Mr. Speaker, I do not intend to be long, but I believe it will be remiss of me if I didn't speak to this piece of legislation, simply because I am ever cognizant of the fact that, one, I gave a promise to the people of St. Philip South that as long as they give me a chance to be a voice in this honorable chamber, that I would do in their best interests. But equally, sir, I speak because I recognize as well that I had a ministry that is perhaps going to be one of the transformational ministries in Barbados, given what this country has been asked to go through over the last 10 years, but equally, given what stands before us in terms of how we can now make Barbados the place where our legislation and our laws form a suitable fit for a 21st century existence, and that government is fit for purpose. Mr. Speaker, I am acutely aware, and indeed, I am concerned about three fundamental areas of law reform that confronts Barbados as we exist in a global environment that says to us that we have to be extremely nimble if you're going to be able to compete on the international platform that no longer gives preferential treatment to Barbados and indeed to our sisters and brothers in the Caribbean. And that equally we have to be extremely nimble if we are to seek to retool and empower and retrain and enfranchise our people at a time where government can do nothing other than try to make sure that we create an enabling environment where people can seek to be empowered and enfranchised rather than rely on a system of the past where people rely on government to create employment and give them minuscule, as far as I am concerned, ownership in Barbados. Gone are the days, Mr. Speaker, sir, when we could exist as a people who look to see others have law reform take place to their own benefit, and to the extent that they continue to enjoy the larger portion of the economic structure, the ownership structure of Barbados, and that those of us, the majority of us, are the ones who will contribute by being non-owner contributors rather than owner contributors. And to that extent, Mr. Speaker, I speak, sir, first of all, about the ministry I'm in. And I want to be very, very clear to all Barbadians, especially as we seek to develop programs within the ministry that speaks to this whole issue of farmer empowerment and enfranchisement drive that we are seeking to bring to Barbados. One, sir, is the whole issue of predial larceny. And right across Barbados, we do know that we have major complaints from farmers as far as the risk involved in farming as it relates to predial larceny. And Mr. Speaker, one of the things that I find to be quite embarrassing, to be very honest with you, but at the same time beats me to figure out how we as a people, and in this very chamber, the law reform as it relates to predial larceny came before this chamber, but that it lacked fundamental things that seek to empower farmers, but rather put them on the other side of the law where they can actually find themselves running up and having difficulty with the law in terms of proof of ownership of goods, proof of ownership of produce, proof of many other things. And that at the same time, whilst this is happening, you have people out there who can rob farmers of their produce, of livestock farming, and all the rest of it. And this is one piece of legislation, certainly, that I believe is up for review, and that we must move at pace if we are going to be nimble to make sure this happens. Mr. Speaker, we are talking to Barbadians about a green economy. And we are talking to Barbadians about how we can make government fit for purpose. And I believe that as a suitable fit for what is taking place in terms of the transformation of Barbados, then we have to look at our pesticides law. Mr. Speaker, I say this because I am one who strongly believes that the organic approach is far better for small island developing states, rather than we continue to go, to my mind, the lazy route of using some very dangerous chemicals and dangerous pesticides in our approach to farming. Now, Mr. Speaker, if we were to look at Barbados, we do need to make sure that we manage our ecosystem to the extent that we are not damaging the environment. And if we are going to remove a carbon emission footprint by 2030, it cannot just because we are removing fossil fuels, but that we look at how dangerous chemicals are getting into our system. And chemicals like glyphosate, sir, that can contribute to cancer in human beings, that is very dangerous to the human reproductive system, Mr. Speaker, sir, are things that we now have to bring before a cabinet of Barbados and make sure then that CPC is able to bring the necessary legislation for us to make our Pesticides Control Board relevant to our 21st century existence. Our coral reefs and the Minister with responsibility for Maritime Affairs and the Blue Economy, the Honourable Member for St. Michael South, will be the first to agree that if we don't protect our coral reef to the extent that we ought to in this 21st century, major opportunities for our people in terms of our fisher folk may be missed, because as we destroy the coral reefs of Barbados through allowing dangerous pesticides to get into the coral reefs, then we throw away an opportunity for tourism, we throw away an opportunity for business, and we throw away opportunities for our fisher folk. Well, Mr. Speaker, as we seek basically to make government fit for purpose and creating that suitable fit within the laws of Barbados, we have to be ever cognizant of the fact that when we talk about dangerous pesticides, that there are those people who might find it easy to put some Roundup or some gramoxone on grass in front of the step, rather than go to a hole and get some very useful exercise, other than using this quick fix that is harmful and dangerous not only to the environment but to the very user. And so control in these areas, Mr. Speaker, sir, I am passionate about, and as Minister of Agriculture, I am adamant that these are areas that we have to address if we are going to make government fit for purpose, and that if we are going to bring about that transformation that is needed in Barbados, because transformation is not just financial, you have social transformation as well. And that if people are so busy going to work and can only find the time to use a spray on some grass in front of a step or in a garden, rather than find the time to pull them or to use a hoe to give them some good exercise, then we know that we have a society that is bordering on laziness, and that we ought to, as a responsible government, make the necessary changes to force people to understand that being fit for purpose means being fit for you, the people, and your existence in this 21st century. Mr. Speaker, I strongly believe that better can be done in terms of our entire approach to the empowerment of people by helping people to understand the responsibility that they hold to themselves as well as a people. Mr. Speaker, over and above what has taken place in terms of the protection of the environment, we also have to look at how we protect our people. And legislation reform in this 21st century then speaks to how we protect our people. Many of our young people are on social media. Many of them innocently are getting involved in contacts in social media. Many of them innocently are getting involved in downloads on social media. And I feel that the time has come, as I did during my days at university, to address the issue of cyberspace law to the extent that we are very, very, very clear about what we are dealing with. And sir, I would want to make reference especially to a case that I saw in Seattle, Washington, where trading was taking place between one distributor in Seattle, Washington, and a retailer in Canada. And that there was a problem with the goods. And that as they tried to address the problem, it came down to who really was the distributor. And Mr. Speaker, within the court of Seattle, Washington, and whilst I don't remember the case offhand, remember I'm not a trained lawyer like the learned Attorney General. In that case, I remember clearly that the law itself didn't allow for the distributor to be identified because it was a cyberspace transaction where there was no clarity as to who was involved in the trade between Seattle, Washington, and Canada. And though I may not be able to cite the law as well as our learned attorneys may be able to, the message that I bring to you, Mr. Speaker, sir, is that cyberspace activity is an area where we now have to be very clear with our laws in terms of the application of taxes and the charge of the fees, etc. Who are you really charging? And who's doing the actual trading must be made very, very clear by way of definition. And whilst it may appear simple at first, as we drill down to find out who is actually involved in the transaction, we may figure that we may have some problems. And I give you one classical example. We all have presence on Instagram and on Facebook and all the rest of it. And you have a group of scams that are now appearing, Mr. Speaker, sir, on Instagram. And some of them are appearing as the Minister of Agriculture, the Minister of Innovation and Sports, the Minister of anything that we have in our cabinet. And they're actually having conversations with the public. But what is coming over is that the people in the public actually believe that is one of us, because there's no way to drill down to determine upfront whether or not it is one of us unless you're smart enough to say, look, let me do some further checking. And even if you do all the checking in the world, Mr. Speaker, sir, you may still have some difficulties afterwards, because a liar is nothing more than a liar. And if a person is prepared to trap you or con you, he or she may determine ahead of you what system and what approach he or she is going to take using cyberspace activity. Mr. Speaker, this, to my mind, presents us with an enormous challenge in this 21st century. And that I believe that Barbados must now be nimble to be able to address this entire matter that came up in a previous Barbados Labour Party administration during the 14 years that we formed the government. And that if we now have to revisit this, Mr. Speaker, sir, then it is important for us to be able to help to make sure that Barbadians are protected, one, from themselves, but equally from cyberspace activity and the dangers involved. Mr. Speaker, there is the Scotland District, where we have to look at Scotland District reform. And Mr. Speaker, I do believe that the time has come where we have to address the issues in the Scotland District, and how we have to be very, very, very clear as to what approach Barbados is going to take as it relates to the Scotland District. Now, Mr. Speaker, I will be the first to admit that this is a highly technical area. But what I will not deny, and Mr. Speaker, where I will not bury my head in the sand and pretend that I'm not aware, is the fact that we have to address the issues there, and we have to bring the proclamation of the reform of the Scotland District. Mr. Speaker, Barbados does not stand alone in this world, and nothing revolves around Barbados, and our existence is so privileged that we can believe that everything we want and everything we should do should happen without the appropriate legislation in place. And I speak, sir, to our ability to trade and trade it in agriculture. And Mr. Speaker, our sanitary and phytosanitary measures are extremely critical to our very existence in terms of the empowerment of our fishermen, the empowerment of our fisherfolk, and the empowerment of our people as they seek to get into agriculture and at the same time understand the opportunities that are available to them in terms of agricultural export, but that we as a responsible government must make sure we move at pace to look at sanitary and phytosanitary measures so that Barbadians can take advantage of the opportunities that are available to them beyond these shores. I speak to these things, Mr. Speaker, sir, because these are exactly the things that I have committees in place in my ministry to deal with. And I'll be the first to say to you that I wish we were able to move as nimble as the Honourable Prime Minister and the Ministry of Finance and the Ministry of Economic Affairs, where they've been able in 3 short months to deliver a fiscal and financial morass that affected this country. And that I feel guilty, sir, that I was not able to bring to the people of Barbados just at the same pace as they did a deliverance program. But Mr. Speaker, sir, you know what is good? One will dovetail the next. Because come next month, the program will come as well. But the committees that I have in place have reported to me, and sanitary and phytosanitary measures isn't small. It is a huge undertaking. And I regret, sir, that it started and we weren't able to finish it, because this started way back. And if we were able to keep pace with what is taking place in a changing world that requires of us to keep up pace, if we are to keep our people empowered, Mr. Speaker, sir, my regret is that we weren't able to maintain the pace. That is why, Mr. Speaker, I'm very proud of our Attorney General, because what he is doing, and he reminds us all the time, he's a very modest man, I must say, but he reminds us all the time that the direction that we have to take this country in and the pace that we have to move at, all of us as line ministers have a responsibility to help him to get us there. And Mr. Speaker, that is why, if nothing else, I wish to commend him for bringing this legislation here so that we can talk through it and let Barbadians know that we are a responsible government, and everything we said that we are going to do to transform Barbados will come through legal or law reform in Barbados that helps Barbadians to get to the next level. Mr. Speaker, I speak to you about our banking system. And, I sound like a stick record, Mr. Speaker, every time I have to speak and say that I've done a number of years in business. And one day, I believe that when I finish my book, Barbadians will get an opportunity to understand what real business struggle really looks like. Because we hear a lot of talk. And we talk and we talk and we talk. But sometimes we don't understand what real struggle is and how you are handicapped by laws that are not suitable for the times that you're existing in. And Mr. Speaker, I have on more than one occasion complimented the Honourable Member for St. Michael North for bringing the FTC into being and legislation in terms of abuse of a dominant position and fair trading practices. But Mr. Speaker, I believe at this time there's an opportunity now for review. And so, Mr. Speaker, as a businessman, I've been able to see firsthand what takes place when the law actually cripples or can handicap business development. And in banking, Mr. Speaker, sir, there are a number of things that we have to look at. First of all, the use of credit cards, Mr. Speaker. I am very strident in my belief that Barbadians literally are owed millions of dollars in credit card transactions in terms of the merchant fees that are charged on top of government or what we call statutory requirements. That if you use your credit card to buy a tin of condensed milk and that carries a VAT, that the merchant fee to the bank actually includes the VAT. And I've been speaking to this, sir, until I feel as though I'm getting blue in the face. I've engaged the banks on it, and as far as I am concerned, the banks themselves admitted to me that yes, this is a problem. But yet it has not been addressed because look, the business that I function in, the tourism industry, the travel trade, you have a tremendous amount of fees that go on airline tickets and people get them mixed up. But at the end of the day, the total sum is being charged 3% and 4% for the use of a credit card. And that money goes to the bank's bottom line, Mr. Speaker, sir. And it includes government taxes. As far as I am known, we need to bring some reform to that. Because there's nowhere else I know that anybody takes a fee on the collection of government taxes. But if that is the case, I stand to be corrected, Mr. Speaker, sir. But equally, I want to submit to this honourable chamber, Mr. Speaker, that it ought to stop. It ought to stop. Because invariably, your markup on a transaction may be 5%, 10%, but that when you take the total sum of fees that you have to pay out, and that 4% or 3% in merchant charges is coming off that total sum, when your markup might only be on the net cost of the product, suddenly you're losing huge amounts of money. And why do we get what people refer to as price gouging? It's because, Mr. Speaker, any good businessman, being constrained by what is happening and understanding that he can do nothing about it, will then take the total sum and put his markup on it. Who loses? The end user. So the final consumer is always penalized for things that we did not move at pace to address, either by way of moral suasion or by way of legislation. And the time has come, Mr. Speaker, sir, and I'm very, very, very passionate about this, because I have seen it real time, where charges are taking place on a final cost, and that you, the businessman, is paying out on VAT and all kinds of different government fees, charges that you didn't first apply. But if you did dare to apply them, the overall cost is greater for the consumer. This has to be addressed. And I have argued, Mr. Speaker, sir, that during that 10 years of the last administration, if they had addressed this, Barbados' economy could not be in the position that it currently finds itself in. And equally, so many businesses would not have closed off, because they themselves would have been able to have a better return on investment simply because they would not be disadvantaged by bank charges. Now, Mr. Speaker, I know people will come and say, well, all you gotta do is pass on charges to the consumer, but I've already made that point. That yes, you can, but what kind of conscience, what kind of corporate conscience you will have, Mr. Speaker, when you understand that something could have cost far less, but just because you are encouraging a practice that you know is wrong, the final consumer pays the price. Mr. Speaker, I am saying in this honourable chamber that law reform needs to take place in order for us to address issues like these. And these things do oftentimes appear to be simple at first, but when we do the complete analysis, we come to realize that it is far more complicated than we actually thought, and that it is something that needed investigation and action long before now. Do you know, Mr. Speaker, sir, that a merchant passing on charges for a credit card is deemed to be engaging in an illegal practice according to the banks? And that they would say to the customers of the bank, don't let them pass on the charge to you, it is illegal. There's a case in the US where Visa actually went to court and lost, simply because, as far as the court was concerned, those charges somebody had to pay, and they were either going to be able to pass them on to the consumer, or the bank had to reconsider their position. I am saying that this is a matter that needs to be addressed. Mr. Speaker, as we look at trading overseas, Mr. Speaker, businesses find themselves with a real problem in terms of intermediary banking. And I have first-hand experience at the challenges that can be involved. You may enter into a transaction where you're doing transfers, and the SWIFT code for the bank, Mr. Speaker, may be correct and all the rest of it. But if there are intermediary challenges on the other side, that is, let's assume I'm doing a transaction between Barbados and Dubai, but I have to have an intermediary bank in the US. But Dubai's banking system is a bit complicated. Then, Mr. Speaker, your money can be in limbo for many, many, many weeks, Mr. Speaker. And that when we speak to intermediary banking, Barbados then has, well, this is a challenge that confronts the Caribbean. But equally, I believe we have to look at legislation within our banking system, because the banks themselves may not have too much control, but what they will do is to protect themselves from risk.
The honourable member has 2 more minutes.
Mr. Speaker, my time flies. They would want to protect themselves from risk, and we can't blame them, Mr. Speaker, sir. But what we have to do then as a responsible government is make sure that we protect our people who have reposed their trust and confidence in us to be able to look after their best interests. Mr. Speaker, I didn't think that I would last so long in this presentation, but I do thank you, Mr. Speaker, for the time. And Mr. Speaker, I am obliged to you.
Honourable member for St. Joseph.
Mr. Speaker, I have to say that I am more than pleasantly surprised at the extent of the contributions by my parliamentary colleagues. As I would have intimated to the chamber, I really didn't expect any robust interventions of any kind, given the relatively dry nature of this particular measure. I am heartened, though, that members of Parliament recognize the importance of all of the issues that I raised, and it would serve no purpose usefully to repeat them. But I think that we operate from the fundamental premise that Barbados has to embrace change and has to embrace modernization. And that part and parcel of embracing change and modernization is that we don't really get to pick and choose in absolute terms all of the things that we want. But more importantly, that we must engage in a constant exercise in reviewing and revising our positions, whether those positions are legal norms or otherwise. You know, Mr. Speaker, just a few weeks ago, this chamber had perhaps the privilege of debating amendments to the Constitution and amendments to the Offences Against the Person Act. And that amendment sought to remove from the laws of Barbados the mandatory death penalty. And the progression from the mandatory death penalty to where we are today went through several iterations. We first had the mandatory death penalty, and then facing challenges by constitutional lawyers and constitutional theorists, we felt it was important to amend our Constitution so that the death penalty would not be considered to be a law that was affected, that was affected by any challenges with the Savings Clause. And then we had a series of cases which represented judicial pronouncements on law, relating to the mandatory death penalty, which among other things said that even though we had not incorporated international treaties on human rights into our domestic law, they remained, or they became part of our law as long as we signed them on the principle of something called Pacta Sunt Servandis, meaning that a country is bound by the pacts that it makes. And then more recently, just a few months ago, we had the Caribbean Court of Justice, which determined that the mandatory death penalty was absolutely and irrevocably unconstitutional. So we've gone yet a further stage. And all of that has resulted in a situation where the Barbados Parliament has been moved by my good self asking that we amend the Constitution and amend the Offence Against the Person Act to remove the mandatory death penalty. I cannot predict where that trend will end, but I think perhaps it is a good case study in how we move from an absolute statement of law at that time which said that a person found guilty of murder shall be sentenced to and shall suffer death. That was what the law used to be. And we have gone through a whole series of progressions, some by way of legislative intervention and others by way of judicial pronouncements. So in that one instance, that one matter, we've gone from an absolute position to variations of it to the position where the Barbados court, where the Barbados Parliament is being asked to completely move to a different grand norm, to a different paradigm. Now, I'm not suggesting, sir, that had we had law reform commissions in place, that law reform commission would have signaled to us we needed to amend our laws, because we do still have to look back in the gallery at the people who sent us here. But it does serve as a practical example of how you can move from something that was settled and that Barbadians felt comfortable with to a position now where we are taking Barbadians a little bit out of their comfort zone. The law, sir, is not static. And the law, it is right that the law should not be static, because it must always reflect the values and traditions and importance of a society as the society itself changes. Now, we are either going to be dragged along by those changes and change in response to things, or we're going to be slightly innovative and say that we need to have a mechanism in place that will allow us constantly to have the legal framework under review and change it as and when it becomes necessary. Mr. Speaker, perhaps for too many years we've been content to be dragged along and to change our statutes only in response to a driving need to do so. But that is not the Barbados that we're in today. The Barbados that I believe is before us is a Barbados that has been colored by a lot of what happened in the lead up to the last election. And in the lead up to the last election, this party came to the country and we said that there were a lot of things that were outdated and outmoded. Things that had served us well for 20, 30, 40, 50 years, things that had served us well for a generation and a half, have stopped serving us as well as we had hoped. And we committed as a political party seeking a mandate from the people, we committed to bringing fresh eyes and a fresh view on our landscape and to making the important decisions so that Barbadians will not just have an opportunity to live in a modern era, but to benefit from all that that modern era holds. But how do we get there? Do we get there by people changing the things around us and we being dragged, kicking and screaming to make those changes? Or do we set out as a conscious thought to be constantly adapting as and when we see fit. I believe, sir, that the latter recommends itself to a Barbados in this era. There are many things that will beset us. We are troubled with a difficult economy. There's a lot of uncertainty, and a lot of Barbadians are worried about what the future holds. But a future that is planned as opposed to a future that occurs through happenstance is a future that is full of promise and opportunity for the Barbadian populace. Therefore, Mr. Speaker, putting a law revision commission in place and putting a law reform commission in place should appeal to all those Barbadians who want to see a planned future, as opposed to a situation where we are responding only to difficulty. There was a time, sir, when the OECD set upon us in the late 90s, early 2000s, and they said that Barbados needed to be blacklisted because we were a jurisdiction that was guilty of ring fencing, and we were practicing harmful taxation, we were a tax haven, a whole set of stuff. And we then had to set about responding to that challenge. The Barbados that we need to take us into the future is a Barbados that, instead of responding to challenges in that way, will be a country, sir, that plans its future, and a country that recognizes the importance of signing on to the best ideals and best standards, whether those are to be found in law or otherwise. I'd like to think, sir, that this, as I described it earlier, as being it's not the sleek body of an automobile. It might be likened more to some small innocuous part, but a part without which the automobile will not function properly. This commission, in particular the Law Reform Commission, will have a lot of work to do. Our laws have lagged behind in terms of corporate matters, in terms of family law issues. There are a lot of things that have developed and gone along and left us behind. And our current structures don't allow us to keep pace with those. And therefore, sir, this particular measure, this particular bill, is one that will help to position us into always being able to respond with alacrity as the need arises. The matters that were raised by my colleagues, I'm grateful for them. I'm very grateful for their participation. I think, Mr. Speaker, that I should apologize for judging them too harshly, or maybe I subjected them to too low a bar. I, for myself, having moved the debate, having moved the passage of this piece of legislation, I am extremely heartened that my colleagues have paid interest in the things that keep me awake all night, struggling to keep the laws of Barbados as they should be. I didn't know that they had such great interest. I'm grateful for their interest, and I'm grateful for the enthusiasm. I'm grateful for the support of the Leader of the Opposition, and I'm grateful for his compliments, though perhaps I would have preferred if he'd whispered them quietly to me as we left the chamber. Mr. Speaker, I think this bill and all that it portends allows us to stand on a proper platform for development and progress. And I therefore commend this bill to the chamber. And with those words, I ask that you do leave the chair. Oh, I see, okay. Well, I've already moved that it be read a second time. I'm obliged to you, sir.
The question is that the Speaker do not leave the chair.
But you don't move it. That be read a second time.
The question, who seconded? The question is that the bill be read a second time. All those honourable members in favour, please say aye.
Aye.
You take the ayes have it.
Yes. I now beg to move that Your Honor, the Speaker, do now leave the chair and that the House resolve itself into committee.
Question is that the Speaker now do leave the chair and that the House resolve itself into committee for further consideration of the bill. All those honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
This House is now in committee. Question is that, could I have a seconder? Second. Question is that clause 1 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say no. Methinks the ayes have it.
Beg to move that clause 2 stand part.
Beg to second that. Question is that clause 2 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Yeah.
Part 2, clauses 3 to 14.
Beg to move that that part 2, clauses 3 to 13. Stand part. 3 to 14 stand part.
I'd like to second that. Question is that clauses 3 to 14 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say no. Methinks the ayes have it.
Part 3, clauses 15 to 24. 15 to 24. Clauses 15 to 28.
Beg to move that clauses 15 to 28 stand part.
Beg to second that. Question is that clauses 15 to 28 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Now part 3, clauses 29 to 34.
Beg to move that part 3, being clauses 29 to 34, stand part.
Beg to second that. Question is that clauses 29 to 34 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Part 5, clauses 35 to 38.
Move that part 4, not part 5, part 4, clauses 35 to 38, stand part.
I'd like to second that. Question is that clauses 35 to 38 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
To move, ma'am, that you now report to His Honour the Speaker the passing of one bill in committee.
I'd like to second that. Question is that I now report to the Speaker the passing of one bill in committee. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
The chairman of committees has reported to me the passing of one bill in committee.
do now pass and be cited as the Law Revision and Law Reform Act of 20. Oh, beg to move this bill be read a third time.
I second that.
Question is that this bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Law Revision and Law Reform Act of 2018.
I second that.
Question is that this bill be so cited and passed. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The bill now stands so cited and passed.
I don't remember. Supplementary note?
So order number 8 on the supplementary order paper. In the name of the Honourable Minister of Finance to move the, on which has been transferred to the acting leader House, to move that the House resolve itself into committee of supply to consider the grant of sums of money for the services of this island.
Question is that the Speaker now leave the chair and resolve itself into committee. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
This House is now in Committee of Supply. Maybe.
The heads. Who calls the heads? Or I just thought? I thought that they called the heads. Madam Chairman, this is a resolution for supplementaries arising from the estimates voted previously in this Parliament. But that's why I asked Nigel. You want suspend? You want suspend for
You want
10
suspend
minutes?
for 3 minutes?
Nigel, you want suspend for 10 minutes while you get sorted out? No, but to be fair to the leader of the opposition. Yeah, so let me suspend for 10 minutes.
Yeah.
I thought that the leader had.
In the name of the acting leader House, to move the personal resolution to grant a sum of $9,908,186 from the consolidated fund and place it at the disposal of the government to supplement the estimates 2018-2019 as shown in the supplementary estimates number 4, 2018-2019, which form the schedule to the resolution. Head 13, Prime Minister's Office, $275,000.
Nigel, you ain't ready yet. Don't worry. Madam Chairman, Head 13 of this supplementary resolution deals with the Program for National Defense and Security Preparedness under, of course, the Office of the Prime Minister. The first supplementary being requested of this Parliament for $100,000 associated with professional fees relating to the Town and Country Planning Office. This arises out of a High Court decision of Barbados 2 years ago, whereby it was said that the Chief Town Planner essentially had no legal authority to deal with Section 18 applications arising under the Town and Country Planning Act, and consequently the Prime Minister's Office's Planning Unit was established on the 18th of April last year to process these applications on behalf of the Prime Minister. This unit, in fact, plans and organizes and oversees, coordinates and administers planning applications referred to the Minister responsible for town planning, which happens to be the Honourable Prime Minister of Barbados under Section 18 of the Town and Country Planning Act, Chapter 240. Of course, with the establishment of this office, you've had to set up staff to furnish the office. And the planning unit is staffed by at this stage, one senior town planner and an administrative assistant. The unit received 72 applications, in fact, in its first year of establishment. And I think we would all agree that given the quantum of applications and the research and administrative processes involved in processing those applications, the current staff of 2 is inadequate to effectively and efficiently deliver such a service. And this, of course, in an era whereby, Madam Chair, this government is certainly looking to speed up the processing of applications in the town planning department, because this is integral to investment in our country and in terms of ease of doing business. And this is an integral part. So this supplementary is for $100,000 to augment the staff complement in that office. Under this program, as well, Program 40, under this head, we have operating expenses of $175,000 in the Office of the Prime Minister. Again, we know that the Prime Minister of Barbados, whoever that person may be, is the head of government within CARICOM cabinet with lead responsibility for the Caribbean single market and economy. And this is, of course, a duty that the Honourable Prime Minister of Barbados has already, within her first 4 months as Prime Minister and lead responsibility Prime Minister of CSME, has taken extremely seriously, even though she's had tremendous responsibility domestically in terms of developing a macroeconomic policy to bring us out of the economic doldrums that we found ourselves in on May the 24th this year. We have had already the CARICOM Heads of Government Conference, at which the Honourable Prime Minister essentially took the lead. Since then, there was a subcommittee of CARICOM Prime Ministers meeting here in Barbados at the Lloyd Erskine Sandyford Centre, and it is expected that a meeting will be convened in the final quarter of the financial year, of this financial year. And this, of course, means that we have to outlay expenses for these meetings, which our Prime Minister will have lead responsibility over. And therefore, we are asking this House to approve this expenditure of $175,000 under Head 13 as well. You call another head? Second.
The question is that Head 13 stand par. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Head 15, Cabinet Office, in the amount of $4,487,113.
The Boundaries Commission, or the E-System, E-Cabinet? Okay. Madam Chair, just let me, I just want to confirm. I don't want to, just one second. Right, the election boundaries.
But they also have
and E-Cabinet. Right, okay. Madam Chair, this Parliament is being asked to approve expenditure of $4,381,613.67 towards the operating expenses associated with the May 24th this year general elections. This would go to the Electoral Boundaries and Boundaries Commission to pay those who worked on behalf of the Commission during the election of the 30 successful members of the Barbados Labour Party. We would recall that early this year, the then government, I believe, voted about $600,000 odd in this Parliament towards those elections, absolutely and totally inadequate. Therefore, it has fallen to this Parliament to vote for payment of those workers on behalf of the Commission, and for other operating expenses, stationery and supplies, publications and broadcast, transportation, the operation of the polling stations and counting centres, as well as other expenditure. And of course, we know this is now, over 4 months since the election, so this is an outstanding matter that needs to be rectified as soon as possible. The other program under this particular head relates to e-cabinet system of government, and again, this is high time that the government of Barbados bring this in. This is to have e-cabinet system to create and facilitate web enablement and digitalization of end-to-end cabinet office operational processes, so that ministries will interact with the cabinet office in terms of cabinet papers and related papers by way of the internet and email, rather than having to photocopy at tremendous expense all the cabinet papers and ministerial papers and other documents. It will allow for cabinet meetings to be conducted leveraging electronic access to the cabinet agenda and to cabinet papers, and in terms of storage and sharing, retrieval and searching for documents and correspondence by use of information technology. And of course, in an era where we are trying to save the environment and save the world, any little bit that we can do, don't mind, of course, we're a small island, we have to identify with the issue of the environment and the adverse effects of the environment, which are caused by climate change, etc. And where we can save paper in any way has to be encouraged, and we have the technology to do so. And we are asking this House to vote to certify that expenditure, $100,000, so we can make this process a reality. I'm obliged to you, ma'am.
Question is that head 15 stand part. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Head 22, Ministry of Information, Broadcasting and Public Affairs, in the amount of $420,519.
Just one thing. I got this here. Where? Okay, realize this mistake here. Realize this mistake here. There's 100,000. Under this head, we are requesting this Parliament to approve the expenditure of $420,519 under the Ministry of Information, Broadcasting and Public Affairs. This expenditure arises out of additional costs relating to proposals emanating from the budgetary proposals and financial statements of the 11th of June this year. Of course, the Ministry of Information and Broadcasting and Public Affairs was created as a separate ministry by the wisdom of the Honourable Prime Minister after the elections. And this money is therefore being sought to supplement the previous provisions which would have been under the office of the Prime Minister, under which that ministry fell previously, and now to create it as a separate ministry with a separate minister. And therefore this expenditure is broken down in terms, of course, of salaries for staff, NIS contribution, which is statutory, utilities, rent, obviously books and publications, and library and supplies and materials and maintenance costs, computer, of course, the general and normal expenditure that will be utilized to run any office or any ministry. I'm obliged to you, Madam Chair. Oh, move that. Move that head 22 stand par.
Like to second that.
Question is that head 22 stand par. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Head 32, Ministry of Foreign Affairs and Foreign Trade, in the amount of $1,338,000.
Oh, thank you. Yeah. Sorry.
In a supplementary for the amount of $1,338,000 $1,000. And this is to help us finish off some activities that we were pursuing during the year and some additional costs that we had. Over the period, there's been some neglect of the overseas missions, things that needed changing, structures, etc. And so we have to spend some money on upgrading some of them. And then we would have had recently new diplomatic postings. We would have had to bring people back in from abroad, bring in all their effects, and then make provision for the new diplomats and so on who were going abroad and will be taking up residence to do business on behalf of Barbados. So this is another part of the provision that we've made here to take care of those particular expenses. The ministry finds itself in a position, ma'am, where we recognize that we have to reorganize ourselves in order to be able to carry out the work which the Prime Minister has and the Cabinet have asked us to do. They've asked us also to intensify our work in terms of building relations with certain key countries and ask us to work at more South-South cooperation with other countries so that we can do business with others that will help to get Barbados to go ahead. So this will mean more conferences and meetings that we would need to attend, and she's asked that we be able to fast track that so that we can get the business of Barbados done as quickly as possible, because we need those engagements to help promote the opportunities for trade, growth and business opportunities, and this is what we will be pursuing with the funds which have been asked for in the supplementary. I'm obliged to you. I ask that Head 32 stand part.
Question is that Head 32 stand part. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Madam Chair, Head 34, Ministry of Finance and Economic Affairs, in the amount of $3,387,554.
Best, go ahead.
This supplementary is being asked to allow the government of Barbados to secure the rights to host the first test match, the first one-day international, and the second one-day international matches of the International Home Series, West Indies versus England in 2019. It is well known that cricket matches between England and the West Indies are very popular, and this is again another part of our sports tourism, if one may look at it that way, which helps to boost our economy. And so therefore we are asking for this supplementary of $3,045,000 to cover the cost of hosting this series. I ask that this stand part.
Question is that Head 34 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it. That's it.
It wasn't in our piece. You report.
Okay. Madam Chair, I beg to move that you do now report to His Honour the Speaker the passing of one money resolution in Committee of Supply.
Second. The question is, I now report to the Speaker the passing of one money resolution.
Yeah, this is the World Cup.
All honourable members in favour, please say aye. Aye. All honourable members against, please say no. Methinks the ayes have it.
The chairman of committees has reported to me the passing of one money resolution.
Your Honour the Speaker, I beg to move that the resolution be now read for a first time.
Beg to second that.
Question is that the resolution be read a first time. All those honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Your Honour the Speaker, I beg to move that this resolution be now read a second time.
Beg to second that.
Question is that the resolution be read a second time. All those honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Your Honour the Speaker, I beg to move that this resolution be agreed to.
Beg to second that.
Question is that the resolution be now agreed. All those honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. This resolution is now agreed upon.
Your Honour, this brings us to the end of government business for the day. I beg to move that this House be now adjourned to Friday, the 19th of October, 2018 at 10 in the morning.
Beg to second that.
Question is that this Honourable House be adjourned until the 19th day of October at Friday at 10 a.m. in the forenoon. All those honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. This Honourable House stands adjourned until Friday, the 19th day of October at 10 a.m. in the forenoon.
No, I say let me shorten this debate.